Welcome. We're so excited to have everyone with us today. This is a very special Seniors Living Smarter seminar, now webinar. And we've had a lot of notices about this, but this is our 50th seminar. And we really want to celebrate that. We're just thrilled with the opportunity we've had to share information with people. I'm Virginia Lazenby. I'm a certified senior downsizing coach and realtor, the host and founder of the Seniors Living Smarter seminars. And we started these because we saw the need for seniors to have information. And we're just so thrilled to have been able to do this. This is our 5th year. And related to that. First of all, I want to thank you all for being with us. And we've had people been with us for the whole 5 years, and that's a great testimonial to the information we provide and their desire to have more information. I just want to give a little preface. I just got a note on my screen that my connection's unstable. We know in the wonderful world of technology and Zoom and virtual meetings, it can be an interesting challenge sometimes, but we do the best that we can with this. And so we will have a great program for you today. I want to do a quick poll today. We have, in fact, we're going to do a couple of polls. When we started meeting 5 years ago, we started at the public library. We were there for a year. Our first several seminars, we had 8 up to 12 people, finally 20, up to 40 eventually. Moved to First Presbyterian. We were down in the basement till we got large enough to be kicked out to the upstairs, continued to grow. And now today, currently we have about 60 people online with us. A lot of people have already made plans to watch the recording afterwards because they couldn't be with us this morning, but I'm excited about what we can offer to people. So I want to see from our participants are here down at the bottom of your screen, I believe is where we'll have the poll. And if you open your poll, launch polling. Are you doing that, Jeff, or do I need to do that?
Yes, I did it.
Okay, I'll keep my hands off. Let me explain who Jeff is. Jeff Cramp works with me on marketing and is our tech person on these webinars and has been a tremendous resource and helps us keep things going, but sometimes the internet has its own mind. So good, you're doing a great job. Let's see if when you came to your first seminar or now webinar, were you at the library, in the basement of the church, upstairs at the church, or joining us with Zoom? Okay, some people are still filling that out, so you're trying to remember where you first came to join us. But it's exciting to see. While we're doing that, I have to say, and I forgot to, I hope Gary Cox is with us today. Gary is a member of First Presbyterian. He came to some of our very first seminars at the public library. When we got to our question and answer time, Gary raised his hand, and I assumed it was a content question, and called on him, and his question was, I just want to know why there are not more people here. This is important information. And at that time, there were probably about 12 people there. And I shared Gary's thoughts, and we've now grown over the years. And Gary's still with us quite often. So people do see the importance of having the information. And for those of us who've been at this, I think of fun stories when we were in the basement, Karen Rayburn rescuing us with sound many times. Moved upstairs, Penny Leone, parish nurse at First Pres, being our soundboard person. We've had such tremendous support. COVID threw us for a little surprise, and so we adapted to go to the Zoom webinars. But over the years, we've had about over 550 people to join us, and we appreciate some have moved, downsized, and moved on. Others have downsized, but keep coming, and that's great. And we're just thrilled to have the community. It's a little challenging now when we're not live and having personal interaction, but we still feel that community spirit. I know a lot of conversations go on outside the seminars. So it's fun to see. We have at least 2 people here who started back in the library days. Another 7 when we were downstairs at the church, and 22 upstairs. And also a lot of these numbers are larger because several of you are couples who are watching. And in fact, we've got to give a shout out to the Strayers. They're watching from northern Minnesota, up on the Gunflint Trail north of Lake Superior, my favorite place. But they took time out from their hikes to be with us today, so we appreciate that. Okay, so we're going to move on for just a minute, and we have another poll we're going to do, keep you involved this morning. Here's, this one's going to require some thinking. I want to see if you can estimate the number of seminars or webinars that you've been to. So, I guess we're supposed to have shared the results, or maybe we did. Can you pull up the next poll, Jeff? I know I changed the order and I messed them up, but thank you for those that voted. So, all right, here's the real challenge one. How many seminars or webinars have you attended? Is today your first? Have you been to somewhere around 2 or 4 or 5 to 7? I don't have the list here to make sure you're being exact, but we have a wide variety. It's kind of fun to see how people keep coming and coming. So let's see what we get here. Some of you are estimating how many times you've been here. We do 11 a year. And so, and if you come half of that time, we missed one a couple years ago, and I had extra hip surgery, and we missed March this year because of COVID. But other than that, 11 a year. So we have, let's see, 4 people who say they've been here more than 30 times, which is great. And we welcome our new people. We have 7 people here for their first time. And I realize some of you see a particular topic of interest and you come, and that's great. And you may decide, okay, I can use other bits of information and return with us. We hope you do. I've had a number of people over the years who comment, well, I didn't think I needed that information or that topic. But then they came and I learned a lot of new stuff too. So we do. We really want these to be informational sessions. We always stress that the purpose of the seminars is to educate, equip, and inspire seniors to make informed decisions and empowered choices. And it came out of my work with seniors as the downsizing coach, as a realtor, to see when people really didn't know what options were out there, perhaps as living communities or resources. And there's so many resources we wanted to make people aware of. For those of you who are new, these are not intended to be marketing. It's information. And you will be meeting our sponsors in just a minute because they do play a very important part with this. But I do have just a couple of, so let's see what, so share results there. Okay, so a nice distribution of, we hope to see more people returning with us. So are the attendees seeing the poll? I'm not, I think they are. I hope. I'm sorry, we have to learn some of the technical things as we go along here. But it's great to see.
I'm showing them.
Okay, good. I never know what I see and what the audience sees, but thank you very much. Okay, I want to move on. I do have a couple of specific recognitions today. And what I want to do, a lot of work goes on behind the scenes, obviously technical work too, but I want to, we have a couple of certificates that we will present at a later time. You can't come up to get your certificate right now. Don't tell me I just lost it. I want to recognize Penny Leone. Penny, as parish life nurse at First Presbyterian, has been a tremendous support from the very beginning. The first year when she was always one, Virginia, what's your topic? I want to put it in my newsletter. I want my seniors to be aware of it. Then when we wanted to think about a relocation from the library, Penny welcomed us to First Presbyterian, and we're so appreciative of that. She helped set up chairs and became our soundboard person. Has been an advocate with the church for us. And Penny, we do appreciate all you've done for us. We have a certificate that I will be getting to you. So I want to, we all give a round of applause. It's one problem being virtual. Then we have another certificate that we're giving to First Presbyterian Church. We so appreciate the church making their facilities available for us, and through Penny's work, when they see our programs as part of their ministry to seniors, it's just been a tremendous opportunity to meet there monthly, and we certainly appreciate the support of the church. And I think Karen Rayburn is with us this morning. Karen's currently on the session. So Karen, we have a certificate. We'll make arrangements to get that probably to you to get to the session. So thank you all very much. All right, I also want to recognize our sponsors. These are people with businesses who so value information. And I know I changed the order, Jeff, but thanks for bearing with me on it. When we put these together, and I reached out to people who I know share a commitment to their business, but also see the importance of seniors really having valuable information so they can make choices. And so our sponsors, when we were live, they had their tables at the church and could visit with you. Now we hope you will still be visiting with them for questions and answers, and you make that available. Our sponsors, and we're going to go back and hear from those who could be with us today. Silver Key Benefits, Traditions Health. I'll come back to individual ones in just a minute. Visiting Angels, Wesleyan, and in my business, Seniors Living Smarter Services. And we welcome a brand new sponsor today. Oops, okay. VERA Bank has joined as a sponsor. Will Boughton, we'll be hearing from him shortly. He was one of our panelists a few weeks ago. He was so impressed by the program, he reached out to VERA Bank to ask that they be a sponsor so they could support this, getting information out to seniors. I'd like for us today to take just a minute for the sponsors to say a word about the services they offer and their commitment, why they see this as such a special offering to seniors. We're going to put you on the spot, Will. While your slide's up there, we'll let you just go ahead and introduce yourself. Well, maybe.
Okay, thanks.
There you go.
Thank you, Virginia. So yeah, I'm Will Boughton. I'm the Trust and Wealth Management Advisor, and now also another hat I'm wearing is that of Investment Portfolio Manager at VERA Bank Wealth Management. You know, we offer a really robust array of fiduciary wealth management services here. It includes financial and estate planning, investment management, trusteeship, and executorship services. We're really, really excited to be a part of this because really the mission of Seniors Living Smarter dovetails really nicely with what our mission is here. And it's really helping our clients, many of whom are seniors, to be prepared for and have plans around a lot of the eventualities of life that we face as we kind of move through this world. And one of the best ways to do that is empowering people with quality information. So, Virginia, I just want to say thank you to your team for what you guys are doing and for inviting us to be part of it.
Well, thank you. We appreciate you joining us. And again, I remind people that these people are leaders within the industry, and I've sought them because of the quality of service and work they provide. But again, we're here to really wanting seniors to have information. Okay, let's see who our next slide is, who we're going to hear from next. Okay, let's hear from Silver Key Benefits. I saw Howard with us earlier. Howard, are you still there?
I am still here, yes. Thank goodness you can't smell me. I just finished playing pickleball this morning, so definitely need a shower. But I am Howard Polanski with Silver Key Benefits. My partner, Steve Dukovic, and I, we help people navigate retirement. Our primary help is in navigating Medicare and how the heck do the policies work, which plan is right for you, because it is not a cookie cutter thing. You know, the next election period is only 2 months away now. It starts October 15th, believe it or not. You know, it's been an interesting year. But I'm just going to say there are 3 major changes. I'll really focus on 2 major changes that are coming up next year. Number 1, if you know people that are on dialysis, Medicare is now opening up to them a lot. So please, if you know anyone that is going on dialysis or is having dialysis treatment, they've got to talk to us to let us know their options. Number two, if you have a Medigap or a supplement policy and you are paying more than $250 a month for it, there is now a way to cap that. So it will not keep going up and up and up on you. I'll stop there, and thank you so much, Virginia.
Okay, we appreciate your sharing that with us. And I think that's the neat thing about our webinars. Yes, we have our topic very important today about probate, wills, and trusts, but we also want to use this opportunity to keep people aware of what is going on. So we're glad to do that. And let's see, next we're going to have Traditions Health. Chris, are you with us this morning? I didn't see Chris able to be with us, but I do want to recognize Chris has been on the panel before, Chris Willis, and he will be on a panel in a couple months. Traditions Health is a hospice program, and he was one of our speakers back in the winter, and so many of us have misunderstandings of hospice. It's so much more than just the very end, how we can enhance the quality of life through that period of time. So we'll be hearing from Chris at other times, and we do appreciate the support of Traditions Health. Visiting Angels, we often generally have Stacy Scarborough with us today, but with us today we have Annabelle. So Annabelle, could you highlight Visiting Angels for us?
Yes, ma'am. Thank you so much. I'm Annabelle Velo. I'm the hiring manager with Visiting Angels, and our office, our agency is home care. We're independently owned and operated, and we help with living assistance services. So meal preparation, medication reminders, housekeeping, personal hygiene, personal care. We're very happy about Virginia sharing all this important information. We fully support you being informed and making informed decisions to ease that stress. There's a lot of misinformation out there, and it can be overwhelming. So we're here to help out, and thank you. Happy to be here.
Thank you. Appreciate that. And she's so right. The misinformation, when people say, oh, well, my neighbor told me. I had some people called me, they were needing some home care, you know, but no one's doing this during COVID. They're not adding, oh, yes, please get the accurate information. And Visiting Angels, other groups too, but we do know they've reached out and provided excellent services. Wesleyan, we have Christy with us today, and Chris Wesleyan offers a wide variety of services. So Christy, can you give us an introduction?
Sure. My name is Christy Schuler, and I'm Community Relations for the Wesleyan, and we are a Ministry of Health and Aging Services. And so everything we do in the Georgetown and Central Texas area is dedicated to really kind of nurturing personal relationships and building spirit. So it was natural for us to partner with Virginia in this program. And we offer independent living, assisted living, memory care, skilled nursing. We do short-term rehab, and we also have our own home health and hospice programs too. So we do a little bit of everything.
And we do appreciate your support. We also know you're a great resource to turn to. I think that's what I know. We often hear Christy and Stacy when they've been on programs to talk. Yes, in some ways they're competitors in terms of providing home care, but certain situations, they may have the right person, and we all want to provide the best we can for seniors, okay? And next, Seniors Living Smarter Services, that's my business. The seminars are kind of an offshoot of this, our service part of our business. As I said, I'm a certified senior downsizing coach and realtor. We really focus on easing that transition. We've heard so many people say it's the importance of having information. Transitions, we're looking perhaps at selling our home, moving to a community, or moving with family. It can just seem so overwhelming. My concern is that causes some people to shut down and never make the move, or not make the move at an appropriate time. And we offer the services I bring together and can very much ease that whole transition so people can really live the quality of life. So, and these seminars grew out of what I saw as a need for people to have information. So I think we are ready to move into our probate, wills, and trust. For those of you who are new with us, we have our panel. We have planned questions that we will share with our panelists, respond. But it's also always becomes pretty spontaneous as new points come up, and so dialogue will pursue. And then we will open it up at the end for questions from the audience. You'll have the opportunity to raise your hand electronically, and we will call on you. So we have with us today 3 panelists. I'm excited to present them. I'll just do, we have Christina Peterson with Peterson & Peterson Attorneys, Sandra Leffler with Leffler Legal Firm, and Wendy Wood, escrow agent with Capital Title. Now, some of you are going, wait a minute, attorneys and an escrow agent. I always like combining the two, because the attorneys give us all the good legal information. But sometimes when the rubber meets the road, especially in the real estate world, and we're getting ready to sell a property, it's like, well, wait, how do we put all this together? And so Wendy's going to help us out with that part too about the title. So there is a method here to our madness. So we're going to get started, and let's see. I can't remember if I'd ask who. Well, I'm just going to start with Christina. You want to give us a little bit more about your business, why you're with us today?
Absolutely. First of all, I'm honored to be here on your 50th Golden Seminar. Thank you for including me. And again, my name is Christina Peterson. Together with my husband and law partner, we have Peterson & Peterson here in Georgetown. We met on the first day of law school at University of Texas Law, and we've been practicing a little over 25 years. Our practice is limited to just estate planning, probate, and guardianship, and we feel strongly about it, that it's important to be caring and informative to people when they are working through life's difficulties, whether that's pre-planning or after they've lost someone.
Okay. Thanks. Glad to have you with us. Sandra.
Yes, good morning. I'm Sandy Leffler, and I have the Leffler Law Firm here in Georgetown. I've been practicing law. I'm in my 33rd year of practice. I first began my practice back in 1987 as a commercial litigator for a very, very large international law firm. But I had the opportunity in 1991 to handle my very first probate. It was an unexpected death of an office mate, a family member of an office mate. And I learned in 1991 I had a real passion for this area of the law. At this time, my practice consists, much as Christina and her husband, I do estate planning, probate, and guardianships. In addition, I do delve into contested matters. Unfortunately, from time to time, a probate will be contested. Guardianships are very highly emotional proceedings as well, and sometimes they do lead to conflict. So I also segue into assisting families and individuals who find themselves in that path and need an advocate to stand for their position.
You know, you're right. We don't like to think about those troubled times, but we do. We know that sometimes people can't work through some of these issues together. I know that's how Christina and I first met, with a situation where the family couldn't come to agreement, and it was very unfortunate. Fortunate for Christina and me, she was the administrator, I was the realtor, and we worked together, and so we all need to be prepared. So thank you, Sandra, for being with us. Wendy, take us to the title world and tell us about your background and why you're here.
Hello, and thank you so much for the opportunity to be a part of this. I really love the information that you bring to everybody. I am an escrow officer with Capital Title, and I have worked in Georgetown for 19 years as an escrow officer. Need to point out, I am not an attorney and I do not give anybody any advice. I am here to talk about underwriting requirements that I've experienced, and to talk a little bit about what title insurance is. Our homeowners insurance, our health insurance, our car insurance, those all protect us from things that may happen in the future. But title insurance protects our real estate from things that may have happened in the past that could challenge our title to our real estate.
All right, so we'll learn more about that, and we can have some interesting situations that can come up, and you have to have an escrow agent who's responsive, and we appreciate what you do for people, Wendy. All right, we're going to move into our discussion now. We always hear, what are those fundamental legal documents we have that we need to have? And I forgot to add a poll. I was curious to see how many of us have these documents in place, how many of us are still on the going to mode. But let's start out. Sandra, you want to start us off on these legal documents that we should have. And I think we have a listing of you have a great handout that we'll make available tomorrow as we get the report out from this webinar. But Sandra, you want to start us off?
Sure, I'd be delighted to. And I would also appreciate Christina chiming in with me on this as well. We did work collectively to assemble a handout, which the attendees and participants will receive, as Virginia mentioned. In terms of the documents that are crucially important, one option with estate planning is having no plan at all. So in that regard, we want to help you overcome the difficulties of perhaps the pitfalls that happen when you don't have those documents. So we dubbed this little set and collection called it the Magnificent Seven, not to be confused with the movie from the 1960s. So starting off at the top of that list, we have wills. Now there are fundamentally two types of wills. You can have what is known as a formal will, which is where you go to an attorney's office and the document is typed for you. It is executed by you, it is signed by two witnesses, and most often is also notarized together with a document called a self-proving affidavit. Another type of will is the holographic will. It is true that you can write your own will. And in a pinch, I can tell you that I'm 58 years old, and 3 times in my lifetime, I wrote a holographic will. I found myself in circumstances where it was midnight and I was going to do some international travel the next day, and I realized I wanted to update something in my will. A holographic will is where you sit down at your kitchen table with a plain sheet of paper and a pen. You start writing with simple words like, this is my will. When I die, this is who I want to be my executor, and this is who is to receive my things. Sign it and date it, and you have a will. Now, a will covers the events that happen from the time of your death forward. The rest of this list covers what happens and number 7 also deals with post-death matters. We'll get to that in a moment. But items 2 through 6 deal with events that occur during your lifetime. So while you're alive, we do benefit from doing some preparation just in case we become ill or have an incapacity and reach a chapter in our lives. Maybe it's a temporary chapter, maybe it's a permanent chapter where we cannot handle our own affairs. Item number 2, the durable power of attorney, assists us with appointing someone to manage our financial or personal business affairs in the event we are unable to do so. You can also elect to sign a durable power of attorney while you're perfectly fine, while you're healthy, to appoint someone to assist you or work in your place to handle those affairs. The medical power of attorney appoints someone to make healthcare decisions for you in the event your doctor certifies that you're unable to do so. The directive to physician is your opportunity to take into your control and in your hands, how do you feel about life support? How do you feel about end-of-life health care if you find yourself in a terminal condition or suffering from an irreversible condition which has left you in such a state that you will die without life support? That also helps your family tremendously because you're taking the burden off of them. They don't have to decide in that famous phrase to pull the plug. You've expressed to them how you feel about end of life. A HIPAA release or waiver is a medical release or a medical consent authorizing persons you designate the authority and permission to speak with your healthcare providers. In fact, it's actually the reverse of that. What you're doing is you're giving your healthcare providers permission to speak with the persons you identify. If you don't have a HIPAA release or medical consent on file, your healthcare providers are held to a strict rule of confidentiality. Everything about your health and your health care is completely private information. So in order to bring your family and loved ones into the circle of care, you would sign a HIPAA release so they could speak with your healthcare representatives. A declaration of guardian is an interesting document because in Texas, our courts don't like guardianships. The law in the state of Texas is if someone has signed a durable power of attorney and a medical power of attorney, they have designated the agents they want to serve on their behalf. However, sometimes those documents fail to work or they're lost or cannot be located. If you sign a declaration of guardian, you are stating to the world, should I ever need a legal guardian, these are the persons I want to serve as the guardian of my person. And that would be the person overseeing your health care, where you would reside and so forth, if you could not make those decisions. And then the guardian over your estate, which is the person who oversees your assets and your financial matters. And then finally, the appointment for disposition of remains. It's not uncommon for a family member or loved ones not to know exactly what your wishes are upon death. And I've experienced families who actually bicker over whether mother or dad wanted to be cremated or not, or should they be buried and where should we put them and what would they like. There are also many clients who want to make other arrangements such as organ donation. And the appointment for disposition of remains gives you the opportunity to designate in writing now what your wishes are for your disposition upon your death. So that's a summary of the Magnificent Seven.
A lot of information. And I'm going to let Christina add some comments. I do appreciate the two of you working together on this, and the handout that they prepared goes through each of those with a description, so you will be getting that so you can hold on to it. I know there was a lot to take in then. Christina, anything else you want to add to that?
You know, I think that really covers it. The only thing I would add on the declaration of guardian on why it is important is do keep in mind sometimes with dementia, we can be taken advantage of. So if ever the family is in dispute later on, the declaration of guardian is very important because you can lay out who you trust to take care of your finances and of your person if later you're unable to make that decision. And also if you make a new friend, I've seen this happen quite a bit. I make a new friend and he is 30 years younger than me, but he loves me for the woman that I am. And we're going to go to Vegas and we're going to spend all our money. And so that's not a good decision. The family has got to come in. And even though because of the dementia, I now distrust my family, this document will show that at the time I was healthy, I did trust them.
You know, those are topics we don't want to deal with, but so much better to deal with them ahead of time and to have a plan in place and for people to be aware. So we just encourage people to think about that. A trust. This is always an interesting discussion. What is a trust and who needs a trust? I know I see myself kind of learning new things all the time about this. Christina, tell us a little bit about the trust. Who needs a trust? I know you all have that on your your handout also, but could you highlight that for us?
Absolutely. A trust is basically a set of instructions for how you want your assets handled, and it can be a testamentary trust within your will. It can also be a trust that you create while you're living, which we would recommend. And it's not just who gets your assets, but how do they get your assets? Do they get them at a certain age? Can it only be for educational purposes? It's controlling how the assets are handled. Now, who needs a trust? Well, and let me just say, feel free to count how many times I say, or Sandy and I say, it depends. Okay. Play attorney bingo. Okay. You get a point for every time I say it depends. If you have property, real estate outside of Texas, a trust is going to be advantageous because there doesn't have to be a separate probate for that asset. If you have beneficiaries that have special needs and they are receiving government benefits, then you're going to want to look at a trust to protect those benefits. If you have beneficiaries that you have concerns about because they have alcohol or substance abuse issues and them receiving an outright amount of money would be dangerous and inadvisable. If you have young children and you want to make it easier so that the trustee will have access to the funds to care for those children. And there's a lot of different things. Sandy, I know I'm forgetting things. What comes to your mind?
Another circumstance that where a trust is beneficial is if you have a blended family, and let's say perhaps you want to make sure that you take care of that spouse of yours, the later marriage in life, but then upon the second death, you want to make sure that whatever's left comes back perhaps to your children or some assets to both sides of the family. Trusts are wonderful with blended families. They're also wonderful to ward off battles between blended families. I've had clients come in and express their concern about, well, everything's okay right now, but I'm really worried about his kids. Once he dies, I'm worried about doing battle with them over money, or vice versa. A husband will express, gosh, you know, we get along okay with the children, but what happens if my wife dies? I'm living in her house right now. And just sort of setting out those rules ahead of time so that the clients themselves get to write their own roadmap. And I don't know about you, Christina, I think you might agree that for people who do have trusts, it greatly narrows the amount of conflict that follows after a death, because it's all set in stone by then. And really people can't change those rules after the fact.
Absolutely, absolutely. Because sometimes with blended families, if I have children and a new spouse, I'm the glue that holds it together. And when I pass, the relationship, they don't have to play nice anymore.
Absolutely.
Again, we don't like to think that things like that happen, but it does. And we're going to come back a little bit later about trust in real estate and the selling of properties. We're going to save that for just a few minutes, Wendy. I want to switch for just a minute. We've been kind of on a series of topics related to this for the last few months, as it turned out. We've had a number of people to ask, what happens when a person does not have any family to serve as executor of their will? It's come up in a number of ways. Sandra, you want to start us off on that one?
I have to say that's, pardon me, one of the most complicated estate planning issues. And it isn't uncommon, particularly here in Georgetown with its demographic. So many people move here to retire, and perhaps their children are halfway across the country, or they have no children. Whenever I'm confronted with a client with that planning issue, I usually we begin a back and forth, a dialogue, sort of an interview. Now, just for all persons, what are your options? a very close friend, a different relative. If you don't have children, are you close to a niece or a nephew? Do you have someone else in your family tree with whom someone you trust and with whom you have a relationship? Sometimes the answer is no, I don't have any of those people. I don't have any friends like that. I had a video call yesterday with two sisters. One is a new widow and the other never married, and neither of them have children, and they didn't go through life collecting friends. So for them, they are looking for a professional third-party fiduciary. With VERA Bank introducing itself this morning as a sponsor, I want to know more about their organization. It seems that they, for example, provide executor services as well as trustee services. So you have institutionalized oversight. There are a couple of organizations in the greater Austin area. For example, there is Austin Trust Company. There's another company called Family Elder Care, another company called Care For. And each of these organizations have departments and individuals who are trained in this area as professional fiduciaries. I will say that in recent years, banks seem to be getting out of that business. So whereas previously a national bank such as a Bank of America or Wells Fargo, they're starting to pull away from that. A big announcement this year was even USAA is closing its trust management department. So for a client who has that situation, I think it's very important to observe each of those options and look at the upside and the downside. I have observed in our community here that from time to time, local attorneys will end up serving as an executor, for example, for their clients, presumably if they just had no one else. I've seen that in the courthouse from time to time, where a lawyer is there being appointed as an executor for an estate. So there are definitely issues, and it's something that I call it's kind of like going shoe shopping. You try on a shoe, and you try on a shoe, and you try on a shoe, and you consider each one of these alternatives until you find the thing that just fits right for you.
And I know both of you, I appreciate what you said about the dialogue when you visit with people, you know, what might be a recommendation for that person. And I've heard people to share with me, they've heard a variety of people who've worked with each of you, as it turns out, on planning for this. Christina, what do you want to add to this?
Yeah, I think that covers it. I really do. I think it's keep an open mind. It does not have to be a family member. It can be a professional. It can be a friend. It could be your CPA. I've had people choose a CPA.
Most importantly is do something about it. Plan ahead. It's not something you want to wait until the crisis occurs. While you're of sound mind and could think through this, have that plan in place. And so we just keep hearing that message over and over. Very important there. Okay. I think that we kind of covered a couple of things there too. One I wanted to pick up on was kind of like referred when changes change, or when there are changes within a family, someone passes away or whatever. When do people need to update their wills? This is a question that already come in online yesterday. Someone said, when do we need to update our will? How do we go about that? You want to start us off on that one, Christina?
Absolutely. There's no expiration date on a will, but it is important if there has been changes in your family. So if you had small children when you wrote your will and you made your mother your executor, well, now your children are grown and your mother's elderly, you probably want to have the children be executor or maybe not. But as you know, your beneficiaries' weaknesses and strengths, I think if that has changed, if there's been a death of a beneficiary, you may want to look at that and say, will the will cover this? The will can still take that into account, but it may not be the way that you want. So I would think if there's changes in the family or in your beneficiaries, or a substantial change in your estate value, then you may want to look at it and consider making changes.
Okay. Back to what was said earlier several times about the blended families. I think that's always that issue that comes up. We just want to make sure that everybody's on the same page, I guess, and that we don't take for granted. I like Sandra made it very clear a while ago, everything is great while we're all here, but what happens if, and so to be prepared, I think that relates to that too. I want to move on. I know we're going pretty quickly through these, but I want to cover a variety of topics and then have time for questions and answers. Probate, that's always a question about, okay, when is probate required? What's involved in probate? So we'll let Christina start us off on that one.
Okay, so there's different methods of probate, and you can have a very simple probate, or you can also ask for an administration of the estate. Now, what that means is you're entering the will in, and you want it accepted as the decedent's last will and testament. Okay, so that could be simply a muniment, what we call a muniment of title, where it is just simply transferring. It's saying whatever the will says, that property is now transferred to the beneficiaries, but we don't need to pay any bills. We don't need to collect assets. It's usually used for just real estate. Or you can have a complete administration where an executor is appointed, and they then will pay bills, collect assets, and distribute to the ultimate beneficiaries. When is it needed? It's needed. It may not be needed if, let's say, I have moved into assisted living, I pay monthly, it's a rent, I sold my car, I have bank accounts, and they're all payable on death to my beneficiaries. But if title needs to transfer, or I didn't leave a beneficiary on my bank accounts, and the bank says we want letters testamentary, that's when you know that you need to proceed with a probate.
I think that's what you mean. Okay, broke up there for a minute. Okay. So that's if you need the letters of testamentary, that's when you need to have it probated.
Right. That's kind of that's a very simplistic way of putting it, but that's if you go to the bank and they say we need that, that's telling you that there's no beneficiary on that account.
Okay. Anything you want to add, Sandra?
You would be surprised, or may be surprised, how many people believe that just by having a will, they don't need to do probate. And that is probably one of the more common myths about what happens with our estate when we die. And as Christina said, whether you have a probate really turns upon what assets do you have, and how are they owned or titled at the time of your death. And then that will then determine whether you need to do a probate or not. It's not whether you have a will or not, it's all about what assets do you have.
And that's a good lead in to hear from Wendy. Speaking of assets and wills and probate, when people are selling a property, and I know there are a number of times I've been in a situation where a couple owns a home. One of them has passed away, there is a will, and oh no, I don't need to have it probated, it goes to me. I said, no, we haven't had it probated. My neighbor said, I don't need to have it probated. Wendy, what is your response to that situation?
Well, the reason that I'm here is to talk about underwriting guidelines when you sell real property. Mm-hmm. And absolutely, with estate planning, it should help avoid any issues when you are trying to convey the real property. We research things because we want to be sure that there's no fraud, there's no forgery, there's no elder abuse, those type of things. Regarding a will that's probated, when the will is probated, our underwriters would review the probate and then title would pass accordingly. If there is a will, but it's not been probated, as the title company, we are not going to tell you, you need to have your will probated. That is your decision. But in order for us to ensure title, we would look at the will and we may accept an affidavit of heirship. And if we do, then we would require all of the devasees in the will, which the devasees are the people that the decedent is leaving their assets to. So we would require that they join in the transaction and any heirs at law. And heirs at law are determined by the Texas descent and distribution laws. So that's how we can ensure a transaction with a will that's not been probated.
And I want to say, while Wendy was speaking about that, again, a lot of information. We go, whoa, what does all that mean? Wendy prepared a nice handout too that we'll have available with our follow-up about title insurance. And I'm glad she clarified that. We go, oh, it's the underwriters. What does that do? And anyway, they want to make sure, just as a lender, a loan involves going to the underwriter, that that lender is comfortable insuring, loaning on that. The same thing with a title company. It's a safe property for them to not have any risk associated with the sale of that. And so it's not a one size fits all in some of these questions. It has to be reviewed, and we appreciate Wendy's patience with some of us when we want to answer right now about a situation when we're trying to sell a property, but you will be getting this information too. Okay, I want to follow up with Wendy just a minute more on legal issues with real estate. A question that comes up quite often is, okay, I have power of attorney for my mother. Can I just sign for her? Wendy, help us out with that one from when we're signing real estate documents.
Sure. When we're using a power of attorney, of course, the power of attorney has to be reviewed by the underwriter to make sure that it matches all of our underwriting guidelines and requirements. If we believe that the person was not competent when they executed the power of attorney or any legal documents that we're reviewing, we will have to have proof that they were competent. A lot of times the best way to do that is when you are competent, when you're healthy and you're having the documents executed, obtain a letter from your attending physician that confirms that you were competent on that day. And that takes care of everything. If you don't have that letter from the attending physician, we would require one. There are some workarounds because sometimes it can be difficult to go back and find that attending physician that's willing to write the letter. So there are some workarounds that we try to work through with our underwriters to get to their comfort level about the risk of relying on the power of attorney or any other documents that were executed.
Okay. And I'm just going to, of a situation we're dealing with right now, and we've been talking about trust. When a property is in a trust, you cannot use the power of attorney because you have to go through the succession of the trust. It's kind of a simple way of explaining it, but I know I've had some other people to say, well, we use the power of attorney, but it depends, back to Christina. It's the situation, but that is a blanket right there, that when a property is owned by the trust, you go through the succession of trustees. Is that correct, Wendy? For a non-legal, non-escrow person.
That is my understanding. The trust agreement would be reviewed by the underwriter to determine who is authorized to sign for the trust. If any of the trustees are deceased, then we would look towards the succession of trustees in the trust. Yes.
Okay. Now this kind of dovetails on that. So properties co-owned by a couple, one of the couple's deceased, does go back to, well, so my husband and I, something happened to me and so my husband's ready to sell the property. Can he just sign because it was community property? We have that question a lot.
With no will?
Okay, we'll start with no will.
If there was no will at all, then we call that dying intestate. Underwriting may accept an affidavit of heirship that we would first determine all the heirs at law per the Texas Descent and Distribution Law. So if you have a situation where husband and wife have children and there are no other children other than the ones they have together, then yes, you would probably be able to sign for the spouse that is deceased. Because the way and this is my understanding, the way the Texas Descent and Distribution laws work is that community property would pass to the surviving spouse. Now, if there are children outside of the marriage, then the surviving spouse would retain their interest, their 50% interest in the property, but the decedent's 50% interest would be divided by the heirs at law that are determined by the affidavit of heirship. And that affidavit of heirship has to be witnessed by two people, two disinterested people. And they have to have personal knowledge of the decedent's marital and family history. Sometimes that's hard to find down the road.
Yes, we've experienced that. So, okay. Now that was if there was no will. If there is a will?
If there is a will, it depends on what the will directs as to who can sign for them. And then again, if there's a will, but not probated, then that kind of combines everything that happens with the devisees in the will, who they left everything to, and the heirs at law. And for title insurance purposes, we would require all of them to sign. So the answer is no, not just the spouse at that point.
Okay. We need accurate information because I know there's a lot of misinformation floating around out there. Before we go on and ask for questions from the audience, our attendees today, are there things that you've thought of that we haven't covered, Christina or Sandra or Wendy, that you'd like to bring up at this time?
I would like to ask Wendy a question. There was a new document that hit the stands about 5 years ago called the Transfer on Death Deed. That is a deed that allows you during your lifetime, and if you're married, you and your spouse, to designate someone as a beneficiary on your real estate to receive that asset at the time of their death. Now, when the law was first enacted, the statute, our legislature actually drafted a form for such a deed and put it in the statutes. But in 2019, the legislature amended that statute and deleted and removed the form. And in the early years of these deeds being adopted, title companies at first raised a big red flag and said, we don't like these. And the reason we don't like these is if you take your real estate and just give it away to someone when you die, and if you take all your financial accounts and put beneficiaries on those, and those all go directly to someone, what's to say that a creditor isn't going to come knocking a year from now looking to get paid if they were owed money by you when you died? So recent literature I've read still seems to indicate some degree of caution by title companies. And I wonder, Wendy, if you could shed some light on the transfer on death deed and what your experience has been from an underwriting standpoint.
I think the underwriting guidelines have loosened a bit lately. We don't see a whole lot of them, so I don't have a great deal of experience. What I have experienced, though, has been fairly easy to get through underwriting. We just get a copy of the death certificate, and then we have affidavits signed to ensure or to help reduce the risk of that creditor coming and knocking on the door. Perhaps what we call an affidavit of debts and liens that they would sign, and they would attest that there are no creditors that are going to come knock on the door. One of the things that I experienced is when the grantor or the person that's conveying the property to the other person in the transfer on death deed is still alive and they want to sell the property. I have seen some underwriters that will require that the grantee or the one that they assign their property to upon their death, we sometimes will also ask them to join in the transaction just to cover any interest that they may have, not determining that they do have an interest, but just to cover any interest that they may have.
Okay. Thanks for asking that, Sandra, because I know that had been a question that someone had asked. And again, that's one of those things we hear thrown about. Oh, it's all taken care of. We're just going to do a transfer and death deed. The rest of us, people don't really know what that means. And it has, as I've seen how it's changed over the years too, with people's responses to it. So anything else that, before we open it up, Christina or Wendy? Wendy, are there any things that we haven't covered? I know with just that whole real estate,
I think we've covered a lot, and actually I'm excited to hear the questions that they have.
Okay, be prepared. You never know. All right, now for our attendees, if in your screen you have the opportunity to raise your hand, and Jeff, you'll help me, and we'll see who has questions. We will unmute you. This becomes a joint effort, trying to get people unmuted, so you can ask your question. If you have a question, raise your hand. Hopefully we're going to have people with questions. If we don't have questions, it's because Kathy Rice is not on here today. She was, oh, there they come. I've spoken with her this morning. She had a list of questions, but she had a repair person coming to her house, so she wasn't sure she was going to.
She's able to raise her hand.
Since you asked that 5 years ago, we have a lot of people here, but let's hear from Gary Cox, hopefully. Gary? And sometimes I think, okay, Gary, okay.
Can you hear me now?
Yes.
There he is. Hi, Gary.
Can you hear me?
We hear you.
First of all, I just want to say congratulations, Virginia, on your 50th seminar. And thank you for the kind words where you mentioned me as having been at one of the first ones and made a comment that I believe more people should be hearing this. And living in Sun City with all of the seniors and all the seniors in Georgetown, even if you have 50, 60, 70, 80 on the seminar, I think the information that you make available to us, there should be much more people also signing up today instead of 4 or 5 years ago. One other comment that I want to make is that sometimes the seminars are a repeat of seminars that you've had before. But one of the things that I have learned that if you attend a hearing, a seminar, whatever, you're learning something new. And the second time you hear that same subject matter, you kind of remember. And by the time you've seen it or heard it the third time, now you start to understand. So there's a learning process, even though the seminars are repeat, there's new participants, there's new subject matter, times change, and you better can remember some of the things that are so valuable for seniors at this time in their life to know how to handle many of the challenges that we face. So again,
That's true.
thank you.
Thank you, Gary. And he's right. We have similar topics, but I know someone said, oh, I've already heard that topic. I'm not coming this time. Well, fine. Certainly your choice, but it's always different. We have different panelists. Sometimes we may have some repeat, but it's a different, as Gary said, a different time. We're in a different place. So we hear differently the content, we enter into a conversation with different needs. So I appreciate that. We're supposed to have an article in the Williamson County Sun, not this weekend, but the following weekend, about the 5 years of the seminars. We need to, we did record, have Gary's comments there about the potential impact for the seminars. So thank you, Gary. Jeff, I think probably better if you unmute. So let's hear Catherine. Can we hear from Catherine Meisner?
Yeah, actually, I'll ask the question. I'm
Oh.
Jerry. So,
Oh, okay. We'll let you speak too, Jerry.
thanks.
Okay.
We know Sandy. Anyway, my question has to do with death certificates. You know, how do you need them, and for what? Is it for real estate transfers, trust, whatever? And that, you know, how many do you need? Where do you get them from? That's basically it.
Good question. I'm gonna just jump to Wendy and then we'll come back to the attorneys too, because just had this conversation yesterday in Virginia. They need to there's a copy of the certificate. Oh, that's right. That was again the trust one. So, well, let's finish that. Do you always need a copy of the death certificate for real estate transaction? And then we'll come back to the attorneys.
If the will is probated, no. If the will is not probated and we're going to do an affidavit of heirship, then yes. If there's a trust agreement and one of the trustees is deceased, yes. So we will need the death certificate in almost every situation except for if the will is probated.
Okay. All right. Thank you. Sandra or Christina, how many death certificates do we need?
It depends.
That was the most original.
On the number of assets that are going to need to be transferred. So for each bank account, you're going to want to have more rather than less, because it's easy to get them initially and a little bit more of a headache to get them later. And they're usually ordered from the funeral home. They usually will take care of that for you. I would say you'd want no less than 5. Just depending on how many accounts are out there. Sandy, what's your?
I agree with you. I mean, there's no magic number because every estate's different. You know, if your decedent had one bank account and one piece of real estate. Oh, and by the way, we always need a death certificate when we initiate a probate proceeding. So we do deliver an original death certificate to the courthouse, and that typically is returned to us. Pre-COVID, it was returned to us the day we appeared in court, and then walked next door to the clerk's office and she would hand it back to us. We're now doing those hearings and events by submission of paperwork, and we don't even see a judge very often now in a probate, but you'll always need one for the probate. And then, as Christina said, however many bank accounts you have, you usually have to relinquish one to each institution.
So Meisners, did that help you with your question? They may become muted. Okay, let's move on. Jeff, how about if we hear from Deloy Davidson? Deloy's been with us for a number of years too.
Yes, can you hear me?
Yes.
Very good. Wife and I have moved to Texas from Iowa. We did wills, trusts, durable powers of attorney, medical PA, directives in Iowa in 2005. Those were all done by an attorney and filed and so forth. Are those valid in Texas?
Okay, good question. Who wants to go first?
I'll take it.
Go right ahead, Christina.
Go, Christina.
Yes, they are valid in Texas. There's nothing, Texas will recognize them. However, it may be, there may be magic language that we have in Texas that they don't have in Iowa. We have the independent administration. They probably have something similar but word it differently. Some states do not have independent administration. So it may be the sort of thing that you would just kind of want someone to review it and be sure it's still good. What would be more of concern would be your powers of attorney. Those I do see varying from state to state. And Sandra, now that I interrupted you, and
no, you didn't interrupt at all. I'm glad you mentioned the powers of attorney. When you read the language of the powers of attorney from another state and even from Texas, Eventually, somewhere in that document, you will find where it will say that you are conferring upon the agent all of the powers set forth in, and then it sets forth a statute. So coming from Iowa, if you were to take your Iowa power of attorney, your agent is being granted certain powers under an Iowa statute. But as they said in The Wizard of Oz, Dorothy, we're not in Kansas anymore. We're not in Iowa anymore. If you don't own property there, it could become dicey as to whether or not you could accomplish all that you needed to with a power of attorney from another state. Additionally, as Christina said, yes, those documents are recognized in this state, but I had just to share a brief story. I had a client who checked into the hospital to have some tests run, and she was going to be there for 3 days. She wasn't having surgery, but when she was at admission, they asked her whether she had a medical power of attorney, an advance directive, or any other HIPAA release medical related documents. She had moved here from Florida, and she had all of her documents from Florida, and she had made an appointment with me to update those documents, but not before she went into the hospital for her tests. She handed the admissions clerk her Florida documents, and the Florida clerk the admissions clerk looked at them and said, "Oh, we can't use those here," and actually rejected all of her medical documents, which made her feel very unsettled and very uncomfortable. The reality is that the admissions clerk was misinformed, but it just goes to show you sometimes there are even indirect advantages to having your documents replaced with the Texas format that is familiar to the healthcare industry here as well. Especially with regard to something like an advance directive. When it comes to life and death and reading the particulars of what your choices are in terms of medical care or abstaining from medical care, I would think that any healthcare provider might feel a little bit more comfortable with a document that they've read before and interpreted.
Okay.
Okay, thank you. Thank you to everybody.
Okay, thank you, Deloy. Don Garvey. Let's see if we can hear he and Connie are frequent attenders of the seminars, webinars.
Can you hear me?
Yes.
Okay. Question is regarding HIPAA. If somebody has been with you at a doctor's office, with the doctor discussing all of these matters, do you still need a HIPAA signed agreement?
I would say
It depends.
If a person has been with you at the doctor's office, with the doctor discussing all of these matters, does that qualify as a HIPAA agreement, or do you need a signed HIPAA agreement for that person to talk again to the doctor?
Well, in my opinion, I think that as a practical matter, doctors are polite. And if you invite someone into an examination room with you, clearly you've expressed that you don't have an objection to discuss these matters in front of them. But that may not help you, let's say, a week later, if the person who accompanied you picked up the telephone, tried to contact your doctor, tried to speak with the staff, tried to obtain a medical record. The presence of a person is no substitution for an actual signed HIPAA release. I will say, too, that some medical offices will provide one to you. And so some patients are able to find great convenience in asking for one if they know they don't have one, and then they can, submit it to the doctor then.
Also keep in mind that agreement would only be, even if that particular doctor has agreed, that wouldn't pertain to your spouse collapses in the grocery store and is taken by ambulance to a hospital where that doctor is not seeing your spouse. Then just because you have an agreement with this doctor does not mean that carries through to pharmacy, emergency technicians, that sort of thing.
Thank you.
All right, thank you, Don. Beth Varula, I may not be pronouncing your last name correctly. You can help.
That's fine. Can you hear me?
Yes, we do, Beth.
Okay. I just have two questions. How costly is it to make a small change to your wills or your trusts if you just want to edit them a bit? And the second question is, is it feasible, is it a smart thing to do to include a letter to someone in your will or trust that kind of explains to them, you know, why things were done the way they were done? The kind
Interesting question.
of hard feelings.
Okay.
You want me to go?
Go, Christina.
Okay. I think the letter is especially important if you feel that there would be some misunderstanding or some resentment, hurt. My experience has been that if they see it in your handwriting, they will understand it more versus thinking somebody put you up to this, if that's of concern. And so I think that's very important. I think that goes with even your personal items, making a list of, I want my pearls to go here, I want my earrings to go here, so there's no fighting. Virginia and I have seen fighting, okay, over inexpensive, goofy things, okay? So anything sentimental, guns, jewelry, you want to have that laid out. As far as expense, well, wait for it, here it comes, it depends. You know, if we have already done your initial documents, then revising it is not that expensive. If it's a document done in another state, we're probably going to say it's more cost effective to start from the beginning and do a new will. Sandy, what's your thoughts on that?
Oh, I agree with you. There are a few states where that I find the documents to be kind of generic, I mean, very simply drafted. For example, wills from Kansas, wills from Colorado, where they're very short documents, they're not too terribly convoluted as a will. And so oftentimes just adding a codicil, which is an addendum, another word for an addendum or amendment to your will, can be done. But once you get into too many changes in a will, or if the type of change you're doing to the will might offend someone, if they knew what the will used to say and now they see what you changed, sometimes it's better to just get rid of the old document altogether and have it disappear. So that, let's say that in your old will you left a significant sum of money to someone and then you decided to take that away. Sometimes it's best that people just never know that that existed at all, so you just do a new will. And from a cost standpoint, in our practice, we charge about half to do an amendment to a will versus just writing a new will. And we're talking hundreds of dollars, not thousands of dollars.
Correct.
Okay, good.
Thank you.
All right, let's see, Judy Mayo. Are you with us, Judy? Okay, can we unmute Judy?
Yes.
There.
Oh, can you hear me?
Yes.
Okay, I have two questions. One is concerning, if you have a trust, does it have to be probated? That's number one. And number two is, we've recently been told about this out of hospital, do not resuscitate order from the Texas Department of Health Services. And I don't know if we need that or not. So that's basically my two questions.
Thanks, Judy. So let's see, the first one.
If you have a trust, does it need to be probated?
Trust need to be probated, okay? Who wants to go for that one?
I'll jump on that one. If you funded your trust well, I'll go back to something I said earlier today. Upon your death, we look to see how your assets are owned. So if you had a trust and you transferred, let's say, your real estate into the trust, but maybe you didn't transfer all of your bank accounts or investment accounts in, but you had beneficiaries on those accounts, then we have a situation where there's nothing left to probate. The trust will distribute whatever it owns according to the rules set forth in the trust. Any beneficiary designations or payable on death designations will be honored, and that money goes directly to those persons. There are times when people, I had a matter last year where someone had a trust for many, many years, and about 2 years before the date of death, borrowed a sum of money against their house. And so in order to do the loan document, they had to transfer title of the property out of the trust to their personal name, sign the loan in their personal name, and then they forgot to put their house back into trust. And it was just an oversight. And as a result, we did have to probate that estate.
Okay.
So I want to have Wendy just to pick up on that too, about kind of reinforcing what Sandra was saying, that if the property is in the trust and just have to be probated to move ahead.
Well, I can only speak to the real property.
Yeah.
And just like she said, it would go pursuant to the rules of the trust. But I have also seen people that acquire their property individually, and then they transfer it to a trust. And then say they go to do a home equity loan or some type of loan against the real property, and that lender will not loan to the trust. So they do a deed that puts it back into their individual names, and sometimes they don't go back and put it back into the trust. So when they pass away, it's still in their individual names and not in the name of the trust as they thought it was.
Which is similar to what Sandra was describing.
Exactly, yes. I've seen that quite a few times.
Okay. Okay.
And then,
Okay. Do not resuscitate.
I'll take this one. Okay. The do not resuscitate is usually used when you enter hospice. It means we are going to stand down. We're not going to do anything. And you really don't want that unless, because you may choke on a chicken bone and you want EMS to come and save you. So it's usually only when we're not going to bring you back at all. We're not going, no measures are going to be taken. That's usually a DNR, or do not resuscitate, is different from a directive. And one is emergency, bring you back, and the other one is whether we continue with life support.
Okay. Did that help you, Judy?
Yeah, I think so. It sounds like I don't need it.
No, ma'am. If you're having this conversation, you don't need it.
Okay.
But you want the directive. Okay.
Yes, want the directive, not the DNR.
Okay. Let's move to Reg. Hi, Reg.
Hi there. How are you doing today? Thank you for this.
Thank you for being
I
here.
have 3 questions. When is a trust needed? I mean, I'm a single person. I have 2 children. I think it's very simple. Right now I own my home, and I have investments outside of just normal financing, like checking accounts. Why would I need a trust? Or do I?
Christina, could you address that? I think you covered a few of the criteria earlier.
Well, what do you want to happen to your property when you pass? General terms, you don't have to be. I'm not being nosy. Do you want to go to charity or
divided equally between our 2 children?
Between your 2 children. And again, I got to say it depends. Probably don't need a trust unless you feel concerned that they would not use it properly, that you want to put restrictions on the gift.
Come on, my children are not that young.
Government benefits.
Yeah, my children are 35 and 40 years old, so it's...
And responsible people.
Indeed.
And they're responsible. Then my thinking is you probably don't. Now going back to that, the one benefit of the trust, while you're living, if let's say you felt that there was a history of dementia in your family, or you got a diagnosis that you would become incapacitated, and the trust will allow someone to come in and manage your assets, I think, more smoothly than a power of attorney. But absence that belief that incapacity is a real issue, I don't see a burning need to have a trust, because probate in Texas is not the same as it is in Iowa or Missouri, California. Sandy, you would know more about this, where there's a different fee schedule for
Okay.
assets.
I think, Reg, I appreciate the question, Reg, because I think it can be very general. It can also be specific, so we can't get into complete specifics. But I think it was interesting to hear work through what are some of those criteria that contribute to should we have a trust. Okay. Oh, you had three, so we got one question, Reg. What's next?
Second thing, my children both live out of state, and right now I have my son who lives in California set up as my executor. What problems might there be because he lives out of state?
You really wouldn't have any problems administering your estate from a distance. You know, when you think about as a practical matter, typically when we lose a parent, the family comes. They come to deal with the house. They come to address the personal items that are in the home. They come to have a service, a funeral, a celebration of life. Under the current, we have no idea what's going to happen after the COVID-19 restrictions are lifted. But even under the current scenario for probate, in uncontested matters, we aren't even physically going to court. Your son would be able to sign a document designating what is called a resident agent here in Texas. That's basically nothing more than someone with an address here, and it's usually the lawyer for the estate, so that there's someone here to accept service of process on behalf of your son if the estate were to be sued. But other than that, simply working from a distance is not a reason for him not to be appointed.
Okay.
Okay.
The third question I have, and
we'll send you a bill in a minute, Reg.
well, that's sort of what I'm getting at in a left-handed way, very left-handed way. I have read that the state has basically a do-it-yourself will, that you can just basically choose, fill in the blanks or whatever. Is that still active, and is it legitimate, and is it, for a simple circumstance like what I think mine is, a good idea?
This is going to be a great question for the attorneys. As for me, when someone says, "Oh, I'm going to sell my home myself," I don't need a realtor. Well, maybe. And we know that you can. So, but we know that there are, online wills and all. So we'll open it beyond the state too. But okay, what about do-it-yourself wills?
Well,
I don't recommend them, only unless you understand every word that you are reading in that document and understand how it carries out. I don't recommend them. I will say that whenever we've had people do their own wills, we usually end up with a doozy of a probate, and sometimes the will isn't valid because it wasn't signed correctly. There's all kinds of little pitfalls, but if you know every single one of those rules, I still don't recommend it.
Okay.
I think what we see in certain situations is that you get it done, but we may pay more later on to solve some other issues that come up. We see that variety of areas.
Well said.
Yeah, well, Virginia and I have worked together, and she knows to a certain extent my plans. My ultimate intent is to sell my real estate and live in a rental situation. When I get to that need, I'm not there right now. So that would further simplify things. Basically, all I would have would be basically cash and investments and debt.
Now, there's another good reason to encourage people to move to perhaps independent living or assisted living communities. You don't have to worry about the real estate, which might be another topic to add to one of our future seminars that we'll talk about in just a minute. But okay, no, Reg, you did raise good questions for us.
Thank you.
Okay, I don't think I see any new hands. Do I, Jeff?
No.
And I know our time is running short, so I want to thank our panelists. I know I learned, and I think we all learned something.
Thank you all.
As Gary said, we're in different places at different times, and so we take away different things. And I must say that for, I think it was Christina who first mentioned, it depends. I hate to tell you that's not the first time we've heard that. It seems to be the common thread on many of our topics, but we appreciate the three of you being here to share your expertise, to put together materials that you have that we will make available. And you've been a great resource for us. You know, one of the, I think, an important part of a seminar is when you leave with more questions. I think sometimes it's like, oh, I hadn't thought of that. So now I have new things to think about, and that's really what we want to encourage people to do. You know, if it were not COVID time, we would be adjourning to have a special celebration for our day together for our 50th time. But since it was a little hard to have cake for people scattered everywhere around, or beverages or whatever, I thought, what is a celebration for something like this impacted by COVID-19? Well, what's the commonality during this time? Face mask. So this, and you will be getting, this is, it's under construction, they're being made. We have Seniors Living Smarter face mask that I will be popping by. At least I get to see people that way. I will come, keep my social distance. I have a neat little case. We'll reach out, you reach in, take out your individually wrapped mask. But as a way of celebrating and thanking people for being here during this unusual time. And I especially look forward to meeting those of you who've started coming during the webinars, because I haven't had time to meet many of you. But the mask will be here in a couple weeks, and I'll be making my way through. I will, for people who've been, I'd like to especially celebrate those who've been our regular attendees here 2 or 3 times, or 30 or more. But I look forward to sharing the Seniors Living Smarter mask with you. Anything else we need today before we adjourn? Oh, our next one. We look forward to seeing you in September when we will, our topic, yes. Don't be an ostrich when it's time to go. Now that topic has really generated some interesting discussion. The point I need to clarify it, but when we're thinking about, some of us have a tendency to keep putting things off, but we've talked about, you know what, let's look a little bit more at options. And anyway, so I guess you'll just have to come in September to find out more about what don't be an ostrich when it's time to go means. Our panelists will, yeah, and we're going to stay tuned for that too. I had the panelists agreed, and we look forward to really encouraging people. And I know some of you were squirming because you were the ones who contributed that idea about you make a decision. So we invite you to join us in September. Most importantly, stay safe. Thank you for being with us. And if we could ever help in any way, please reach out. I often have people go, well, you know, I'm thinking about downsizing, but it's just so too much. I can't do it. And shut the door. Well, I'm not going to be doing this for a couple of years, but you know, it's not too early to be sure we're clear about resources and services. And I really enjoy meeting these people to help provide information. So thanks again to our panelists, our sponsors who were here today, and we hope to see you again in September, and hopefully I'll see you before with your Seniors Living Smarter face mask. Bye. Thank you.